Yeah.
Yes, Mr. Chairman.
So, my Lord, I want to cover the ground as fast as possible, but I do want to make it clear that I attach great significance to your Lordship's question, because I think you asked it to me twice. What do you say about the statement that the document is only to be used for the purposes of settlement negotiations?
Yeah.
And there is a twofold answer to that. The answer is that that statement will engage the relevant rule of without prejudice privilege under English law. It will also engage, in this case, Rule 408, either or, and it will import those into any contract. So that statement is the beginning of the analysis, not the end of the analysis. Because the question is, what does that mean? And the English cases say that you can have an implied contract from the use of, for example, the term without prejudice. But the question is, what does it mean? And so in this case, and it's contractual. So in the same way that you can agree for a matter to be without prejudice, save as to costs, you can agree specific terms in relation, contractual terms in relation to that, but you also import into that a whole body of learning. Case law, in the English situation, it will be Unilever and the exceptions, and a great deal of learning in relation to that. What you don't have, and I think this comes back to Lord Justice Nugee's point, which is, well, why can't this court just decide? You have very, very little indeed on Rule 408. So you couldn't, in my submission, construe the matter under 408. You have remarkably little. And the reason for that, and it's not a criticism, but Ocado sidelined that. That wasn't important. It's not mentioned in their legal claim. They don't make very little of it. They say it's not significant. And in this case, you have the additional problem of the implication where there is a reference to 408. So how under English law do you imply a contract if you do that exercise at all? And this is all on the premise that they are to be construed together, as opposed to our submission that they are separate, each one relates to each proceeding. And in our submission, obviously, you can't imply a contract which is inconsistent with an express term. And the express term is 408. Now, all of that is extremely difficult in my submission. It would be difficult with expert evidence at a trial. It's certainly not appropriate to do that on an interim application such as this. And we submit that there's plainly more enough here for you not to be satisfied that Ocado have met any test for the purposes of interim relief, which is effectively final. And to grant the appeal, you would have to be satisfied that we've lost on everything. I think with that, I just quickly would like to show you, unless you don't need it, but just to look at 408 so that you can see what 408 is. It's in the core bundle, it's in the Joint Authorities bundle, tab 3, Joint Authorities bundle 1, tab 3, at page, the relevant part of it starts on page 10. Sorry, page 10. Do you see that at the bottom of the page it starts compromise offers and negotiations? Compromise. Prohibited use is evidence of the following is not admissible on behalf of any party, either to prove or disprove the validity or amount of a disputed claim, or to impeach by a prior inconsistent statement or a contradiction. And then it sets out some subparagraphs 1 and 2, and then you'll see at B, exceptions. The court may admit this evidence for another purpose, such as proving a witness's bias or prejudice, negating a contention of undue delay, or proving an effort to obstruct a criminal investigation or prosecution. Now, you have remarkably little evidence about 408 before the court. I did want to just show you 3 documents, if I may. First of all, the agenda for the meeting, which is in the supplemental bundle, tab 16, page 84.
This is the third London meeting, is it?
Yes, that's right. This is the agenda of the 25th of July for that meeting. So this is the precursor. I won't read it out for obvious reasons, but if you could just remind yourself of paragraph 2, which puts the matter firmly on the agenda.
And the other point is that in respect of this document in paragraph 2, it had been sent in advance of the meeting before 408 had been stipulated.
You're absolutely right, my lady. That is
I
absolutely
can't find a date on it, I have to say that.
I will,
Save in Mr. Ayrton's statement, it says it was sent in advance of the meeting.
Well, I'll see if we can help your ladyship with that.
Do we not see the email?
The email
Under cover of which it was sent?
that
I think it was in tab 14.
Yes, that is 60. Yes, that's
60,
the email of
65.
Yes,
Sent on the 6th of July.
yes, 65. Yes, right at the bottom page, 6th of July 1707. Sending the email over the page at 66, the third line down, third bullet point down. I think your lordship's right. So that's 6th of July. So I think that answers my ladyship's your ladyship's question. What is said against me is that the reference to 408 is a unilateral oral statement. But if you could look on to tab 17, please, which is the meeting minutes, and you'll see at the beginning, the first bullet point, that was a statement by Ocado's own solicitor, Mr. Ayrton. And that was a statement that was recorded in the attendance note prepared by Pal Gilbert and then afterwards provided to my client. And it was a statement made at the start of the meeting at which US law discussions took place and were anticipated by the parties to take place. The only other document I wanted to show you on this is Mr. Brinkman's first statement of paragraphs 19 to 22, which is a supplemental bundle at tab 28. You'll see there the evidence that it was provided to my client. I wonder if I could ask you, just to avoid any danger of referring to anything, but if you could just read 19 and 20 down to the and then 19, 20, and 22, please.
Yeah.
So your Lordship will see that paragraph 22, that is really the extent of the evidence that you have in relation to 408. You can see it's broadly similar, has its own exceptions, but you don't have any sort of extensive analysis of what 408 would entail. But it does show you that the Rule 408 has its own rules, but is broadly similar to our without prejudice.
There's no evidence about the use of the term without prejudice in America. My recollection is they use it a lot.
Yeah, I mean, our case is that these are the two equivalents. They're broadly similar. They're not the same. Obviously, we've never suggested they're the same because each jurisdiction will have its own particular rules, particular exceptions, particular learning.
I mean, they use the term with prejudice.
Yeah, yes, exactly. I think I think it's important that you see this in context, that question, because I think it answers a number of points. The points of principle from the Master of the Rolls, which is, well, simply by saying that it's only for settlement purposes, isn't that sufficient? And in my submission, that's the beginning of the inquiry, not the end. And secondly, Lord Justice Nugee's point, well, can the court just not get on with it and just construe this agreement? And the answer is, I would suggest that would be inappropriate if this were even purely without prejudice, purely domestic proceedings. But here you've got this additional matter of effectively foreign law. And one would normally do that by way of expert evidence, of course, as to precisely what was meant. And it gives rise to all sorts of complicated issues, because even if the case against me, which is it's both, then one has to construe that contract. What does that mean? You need to know the scope and extent of 408. Obviously, the English court is its own expert in relation to what the scope and extent of the without prejudice rule is, but how do they interplay? What was meant by that? If that was really what the parties meant, then that requires some very careful analysis with expert evidence. That's why our submissions...
in this court, we generally assume foreign law to be the same unless there's evidence
except
it's different.
There is evidence, because you have 408 and you have that. So it shows another part of the difficulty. This is all done on an urgent basis. We say that's Ocado's fault because they've left it very late. They told the court they only found out about this on the 20th of May, and their client had known about it much before. And it's all gone in very quickly. But even if that rule were to be applied, you have enough. You have 408. You have the statement of it's not the same. It's not the same in terms. There are plainly differences, and in fact, it's said against me that there are differences. So that is a complicated question in my submission. Even if one were to approach it on the basis that it's both, and the word "and" means that one incorporates both, I don't accept that, because in my submission, the more obvious answer is that the parties were intending English law to be WP and the US to be 408. But I've made my submission on that. But even if I'm wrong about that, and if that submission is wrong, as I say, it's the beginning of the inquiry, not the end, and it's a complicated question. Now, with that, I was going to quickly go through the grounds, the 4 grounds, one by one. And can I ask the...
Can I, just before you do that?
Of course.
We were shown by Mr. Purvis a statement in your skeleton, I think it might have been the skeleton below, but which said that you put the case 2 ways. One was that at the outset,
yes,
the agreement was that the rule of admissibility would depend on each jurisdiction.
yes,
And the other was that it started off just being WP and there was a variation. Is that right? Are you maintaining those 2 alternative ways of putting it?
We would put it, in a sense, I would turn it the other way if I may, which is that what happened on the return date was that there was a great deal more emphasis on Rome 1 and English law.
Yes.
And my submission was it doesn't matter, because if you look at 3.1 in their own submission, I had no issue with their submissions. They were very, their position in relation to Rome 1 was absolutely accurate. But it's very clear that under English law, whole or part of your agreement can be subject to English law or some other law. So it doesn't help them. And similarly, this analysis doesn't help either, because what Ocado need to show is that we're precluded. So whether it's an analysis that it starts out WP because the parties are only concerned with the English proceedings, for example, the US proceedings are going to be discussed, and therefore the position changes, and you have a statement along the lines of the one that you've seen. It doesn't matter either way, because that is a carve-out. It's as if, can I put it this way, in simplistic terms, if it started out being WP, but then one party wanted it to be WP, but going onwards, WP save us to costs, they're perfectly entitled to amend that arrangement, amend the contract. So, in a sense, whatever the legal analysis, it has to be shown against me that it's not possible for my client to have a carve-out. 408, that 408 was ineffective. And in my submission, it's the other way around. It's absolutely crystal clear. I accept that there are debates about whether it's both or whether it's one, and in my submission, the judge was right about that. It would be very unlikely to be both, and that's not what the document says. But that's my submission. So we do, in a sense, we put it every way, which is whatever analysis, all roads lead to Rome. It doesn't really matter in my submission when the US submissions came in. If suddenly, in the middle of the meeting, someone said, I would like now to discuss the US proceedings, we're starting US proceedings, and then the other side said, well, if we're going to talk about the US proceedings, we need to have Rule 408 to apply. Do we agree that Rule 408, so far as we're concerned, from now on, everything is covered by 408 because we're discussing US? Perfectly possible to do that, perfectly legitimate to do that. There would be nothing surprising about that at all. In fact, it would be the other way around usually. If we were saying that it didn't bind and it didn't matter because at some earlier date it was only done on one basis. So, for example, if in an earlier meeting it had been only 408, and then somebody subsequently says, well, it's WP now. You say, well, you can't change the basis upon which the discussion will be made. In my submission, it doesn't really go anywhere at that point. It's perfectly possible for the parties to agree. It's a pure matter of contract. And so whichever way one looks at it, it doesn't affect my submissions. So if I hope that was your Lordship's point, and if I've dealt with it. We did put it a number of ways, I accept that. We put it multiple ways.
What I've understood is you want to carry on putting it as many ways as you can, as long as you end up in the right place.
Exactly, but that's because the case against me is not clear. They haven't said, their pleaded case is very simple. It doesn't even mention 408. They just say we're precluded from referring to these documents.
Yeah.
So until we know exactly what they say, your Lordships are asking, well, when did you make the contract? On what basis? On what date was the contract made? I don't know any of that. And your Lordship and your Ladyship don't know the answer to that because it hasn't been given. The blunt terms in which the pleaded case is put would, in its own terms, preclude the application to Judge Hacon because it said that you can never refer to this document in court for any other purpose. Now, how as a matter of language, that would preclude ever going to a court, even for admissibility. That's how extreme the case is against me. So, and that is coupled with the sidestepping of exclusivity. It's as if they're saying you can't go to any court under any circumstances because you promised not to. But once it's accepted that you can go to court, as they did before Judge Hacon, then the other questions start arising. Well, why one court rather than another, and so on. And your Lordship has my point on that. But I do accept what your Lordship says, but I put my case in that way in my submission with good reason, because I don't know what the case is against me. So if we could go to the grounds, please, which is in the core, tab 5, and I would like to take...
I mean, to say this, I'm not sure the way I put it to you has the effect of preventing an application for an injunction. Because if the contract is, this document may be used for purposes of settlement negotiations only, it's perfectly possible to apply for an injunction to restrain it being used for any other purpose without even asking the court to look at it.
No, my Lord, I wasn't directing my criticism to your Lordship's question. That is a different matter. I was directing my criticism to the way in which the claim had been put in the pleaded in Annex E. And that is the way in which the terms of what is said to be the agreement were put in the pleading.
Yep.
So that was my point,
yes.
not your Lordship's question. So if I may, because I know time is short, and I'm going to run through the grounds. The first ground, and I'd like to take it, if I may, by paragraph and do it by reference to the grounds. I think it will be much quicker if I do that. Starting on page 56, paragraph 3. So the judge erred in concluding at paragraph 54 that the threshold test for an injunction in that case was not whether there was a serious issue to be tried, but whether Ocado has a high probability of succeeding at trial, on the basis that although the application is not for an anti-suit injunction, the grant of the injunction sought would interfere in the conduct of foreign proceedings. And then if you turn, so that's really just setting out what the judge effectively decided. The judge decided it was not the same as an anti-suit, but it was analogous. Then at 4, what they say, Ocado say, the judge should have done is, 1, he says the application to restrain the respondent from disclosing without prejudice material was not in the nature of or equivalent to an anti-suit injunction and didn't engage the legal principles of comity, which in turn have been said to support the high probability of success. Now, in my submission, that betrays a misunderstanding about the nature of the case. An anti-suit injunction involves the enforcement of a promise not to sue elsewhere. That's effectively what it is. I won't take you to all of the material, but we've set it out in our reply skeleton, tab 11, page 150, which is the definition in Raphael. It might be worth actually just looking at Hamilton, which is a very pithy summary, which is in Joint Authorities 2, tab 30, at page 78. And that sets out page 78, and it's 2 paragraphs. It's one paragraph. It's simply paragraph 18. The primary ground on which CMS does the court have that? Yes. Seek to restrain the Antiguan proceedings is that they've been brought in breach of the exclusive jurisdiction clause in clause 30 of the general terms. The basic principles applicable to an anti-suit injunction based on such a clause are not in dispute. The test for determining at the interim stage whether an exclusive jurisdiction clause applies to a claim is whether the applicant has shown to a high degree of probability that it is right, or whether the English court can point with confidence to a contractual promise not to litigate elsewhere. So the focus is on the promise not to litigate elsewhere. Lots of authorities in support of that. It's really beyond argument that that's the test for an anti-suit. And then at the end it says a good arguable case, as in Transfield, or even a strongly arguable case, is not sufficient. And then the second paragraph, an anti-suit injunction is a discretionary remedy. Where there is an English exclusive jurisdiction clause, the discretion will ordinarily be exercised to grant an anti-suit injunction unless there are strong reasons not to exercise it, the burden being on the party opposing the grant of an anti-suit injunction to show that there are such strong reasons, and then that refers to the angelic grace and Donahue and Armco. So it's the other way round, but you have to have the contractual right. Now, it is true that an anti-suit injunction usually restrains the pursuit of entire proceedings, but it can involve a claim rather than entire proceedings, and that's clear from Raphael. And we submit that the restraints of an application to determine admissibility of evidence is sufficient to fall within the label of an anti-suit injunction, because it's effectively based on a promise not to sue elsewhere. But that really isn't the point. It's not about labelling. The issue, as we've explained in our written submissions, is what is the basis upon which the English court can restrain my clients from making an application to the ITC? And the usual way in which that is done is by pointing to, as I say, a contractual right, an exclusive jurisdiction clause, and arbitration agreement. And if that is done, the court can in principle enforce the negative promise not to sue elsewhere in such a contractual agreement, but provided that the test of high probability is satisfied for any interim relief. One of the reasons for that is because with an anti-suit injunction, like this injunction, it's effectively final. So although there is a claim to be brought in due course, the grant of the injunction effectively puts the matter at an end. And as I've said before, in this case, there's no contractual exclusive jurisdiction clause alleged to any standard, and there is no issue asserted by Ocado as to exclusivity. And secondly, on that paragraph, it's not accurate to say that the principles of comity have led to the test of high probability. It's the other way round. The English courts take a less strict approach where an injunction gives effect to a contractual bargain between the parties. In other words, there is a general position of comity, but if a party has promised to another party exclusivity and promised the negative covenant being promising not to sue elsewhere, the court will give effect to that contractual bargain. And that's always been part of my submission. That's been at the core of my submission. That's fundamental, but it's not. Ocado put it the other way around. They need to show the contract to show an exception to the general principles of comity. And in that case, if there is a contract, the English court's giving effect to the contractual bargain between the parties. And so, although it's an indirect interference with a foreign court, it's based on that bargain. But as I say, even in that case, even if that is the case, you have to show that to a high degree of probability to get conjunctive relief. I did want to show you 2 cases, if I may. One is the Court of Appeal decision of Sir Christopher Clark in EcoBank, which is in Authorities Bundle 2 at tab 29. And one of the reasons I want to show you that is, it was argued in that case which was an anti-enforcement case. So it was a case about an injunction after judgment had been obtained in a foreign court, allegedly in breach of an arbitration provision. And it was argued that because the judgment had already been given, the principles of finality didn't apply. But if we could start, please, with paragraph 81 on page 55. So you'll see 81, it puts it in, if a party to an arbitration agreement seeks to litigate a dispute to which the agreement relates in a court outside England and Wales, his opposing party may seek an injunction to restrain him from bringing or continuing that suit. If that party obtains a judgment, his opponent may seek an injunction precluding him from enforcing it. And although such injunctions have different labels, anti-suit and anti-enforcement, they're both based on the fact that the person enjoined is seeking to pursue a suit or enforce a judgment obtained in it when he agreed that the dispute would effectively be resolved by a different method. The attitude of the English courts to the grant of injunctive relief has developed over the years. Initially, there was some reluctance to grant an anti-suit injunction on one or more of the following grounds. It would have the appearance of interfering, at least indirectly, the proceedings of a foreign court. It would be inconsistent with the comity that ought to exist between courts, and it would be offensive to their judiciary. So that's the general position. But such reluctance, at any rate in the case of anti-suit injunctions, almost evaporated with an appreciation of the fact that when the court grants an injunction, it doesn't direct the foreign court to do or restrain from doing anything, something which it has no power to do. It acts in personam, enjoining the party who seeks to litigate elsewhere from doing so in order to enforce the contractual undertaking that the party has given. In acting in this way, it doesn't presume to tell a foreign court what it must or mustn't do. It seeks to give effect to a bargain that the parties have made. And that was so since the end of the 19th century, although I would say it probably wasn't appreciated as quickly as it might have been. And then at 84 and 85, so Lord Justice Christopher Clark says, as a result, anti-suit injunctions have become relatively commonplace when the basis on which they're sought is that the parties have agreed to arbitrate the dispute or have agreed that the English courts shall have exclusive jurisdiction. Again, that is entirely in support of my submission. It has, however, been a theme of the jurisprudence in this field that a litigant who seeks to enjoin his opponent must act promptly. And that's the angelic grace. Thus, in the angelic grace of Lord Justice Millett, as he then was, observed that an English court should feel no diffidence in granting injunction, provided it was sought promptly and before the foreign proceedings were too far advanced. And then I would just like to show you one other part of the judgment, paragraph 89, the threshold test, because that sets out some of the reasoning as to why the test is so high. And at 89, it says, in Midgolf, Mr. Justice Tier held, following Bankers Trust, which itself followed Mr. Justice Coleman in Bankers Trust and Mayora and American International, an applicant for an anti-suit has to show a high degree of probability that there was an arbitration agreement that governed the dispute in question. So in other words, you have to show your arbitration agreement or your exclusive jurisdiction clause, and that it falls within the scope of that provision. In Transfield, I followed this line of authority. Mr. Coleman submits that the rationale for requiring a high probability test is that if an injunction is granted, it's likely to be final, because in practice it will end the foreign proceedings for at least sufficient time to enable the arbitration to take place before any judgment is granted in those proceedings. By comparison, the judgments in this case have been granted. The effect of any order will be to restrain enforcement pending further order of the court or the arbitral tribunal. If the arbitration tribunal decides the African proceedings do not breach the arbitration agreements, Mr. Tanner will be free to enforce those. And then he says at 91, I do not regard it as appropriate to adopt a lower test in the case of an application for an anti-enforcement injunction. In both cases, the injunction would preclude the enjoined party from carrying on either with the trial or with attempts to secure the fruits of a judgment obtained at the trial. In both cases, the English court is interfering, albeit indirectly, with the working or output of a foreign court. In both cases, it could be said that if the arbitral tribunal concludes the arbitration agreement doesn't apply, the respondent will be able to continue with the trial or the enforcement. Further, as Mr. Flynn points out, there was in fact no pending claim for a final injunction. The injunction sought wasn't subject to any specified term. So that shows you the degree of finality in these cases, which is, in that case, they didn't even bother to have a trial of the issue. The injunction was sufficient in itself if they obtained one. The only other case I wanted to show you was the summary of Mrs. Justice Cockrell in Times Trading.
What did Lord Justice Christopher Clark do in that case?
He did not grant the injunction.
On the grounds
by memory.
Been left too late, or there was a doubt over the...
Your Lordship, I can't remember, but I will just look at the end. yes. Look at the head notes, actually. I should actually remember, but I'm always worried if it's a case that I've been in that I misremember. So I just want to make sure I can tell your lordship. If yes, if you look in the head note, sorry, at page 38, this was a case, obviously this was an anti-enforcement case, so what had happened here was that judgments had been obtained in breach of the, said to be in breach of the arbitration provision. The judge below, I think it was Mr. Justice Knowles, discharged the injunction because of the bank's delay in seeking relief. Yes. You see that just above E. And then the head note says that the appeal was dismissed both on general discretionary considerations and the need for comity, require that an application for an anti-suit injunction had to be made at an early stage. And that the longer the foreign action continued without any attempt to restrain it, the less likely to grant an injunction. And then there are the other reasons. Sir Christopher Clark gives a pretty comprehensive judgment. I haven't taken to the rest of it. There's lots of material in there on comity, delay, and so on. Delay being one of the factors that we rely on here, because our submission is that they knew about this much earlier than they told the court. And that, again, is another factor. I'm trying to concentrate on the grounds at the moment, because there's a lot in the respondent's notice. Then, if we could go back to the grounds at paragraph 4.2, in any event, even if principles of comity are engaged and the court is in consequence required to exercise some caution, that doesn't import into the present context the high probability of success standard applicable to anti-suit injunctions. And the question is, why not? Because the reasons I've already given, it can't be a lesser test where you have no contract at all. I mean, the test is there when you have a contract. So the Ocado's case is that there should be a lesser test when they haven't got a contract in relation to exclusive jurisdiction, in relation to exclusivity, of course. So there's no reasoning as to why it should be a lesser test, given that the well-established principles of high probability of success are where there isn't a contract to that effect. Then at 4.3, the effective final consequences of the interim injunction sought justified having some regard to the strength of the parties' cases, and I think that was what the Master of Rolls was adverting to in American Cyanamid. But the case against me is you have some regard to the strength of the parties' cases rather than merely the test of serious issue. And in any view, at that standard, the application for an interim injunction ought to succeed. Now, that is an acknowledgement of the consequences of the interim injunction. In my submission, it's effectively final. But it's not an explanation as to why it's any less a test than high probability. So then what they then say is, now if we're right about that, then we submit the appeal should be dismissed. But what they say at ground 2 is, even if the judge was correct that Ocado had to show a high probability of success, he erred in finding that this test wasn't satisfied. Now again, I think it's important to appreciate that that aligns 2 issues. One is the exclusivity. They need to show a high probability of exclusivity, a high probability of establishing a promise not to sue in the ITC, not to bring this material before the judge in the ITC. And there's a separate question of the high probability test in relation to put it in as best to the merits issues, the 408, without prejudice. And so, so one does have to analyse it in 2 stages. One is firstly exclusivity. If you accept my submissions on that, again, the appeal fails. But then if that's right, one has to ask in relation to the test of high probability in relation to the merits. And that raises the different issues. And I don't want to repeat myself, but that is, what did the parties mean when they said, and any US law discussions would be governed by the Rule 4A law of the rules of evidence. Now, I've probably said as much as can be said, and I hope I've answered the court's questions. But what I would say in relation to that is, can it seriously be said that that is a high probability? That the court can have the comfort of a high probability that Ocado is right on the merits, on their analysis of the position. Now, in my submission, one only has to ask the questions to realise it can't possibly be satisfying a high probability of success test. As I say, it was all said to be WP. It was late attempt to suggest it was both. But the suggestion that it's both, in my submission, as the judge said, it is not a matter that satisfies any high probability test. It raises more questions than it answers. Then at 6, what is said is the judge erred in considering that there was no clear indication as to which party was correct. Ocado had in fact shown that an overwhelming likelihood of success on the merits in the light of the evidence. And then it says the right analysis was that it was common ground that the document in question had been disclosed and accepted for discussion prior to the third London meeting. Now, in a sense, so what? That doesn't get them anywhere. 6b, it was common ground, or not, at least not seriously contested by a respondent, that all discussions, at least up to the first day of the third London meeting, were proceeded on the basis of the English law of confidentiality and without prejudice privilege. Yes, but that only is the introduction to the question of what did the parties mean by their reference to 408. It's a background point. It's not a high probability point. Your Lordship, Lord Justice Nugee was asking me, well, what would be the issues at trial? What's said here is the sort of submission that one might get in closing at a trial. Here it is, well, up until the meeting note, the third meeting, it was without prejudice and confidential. As I say, that doesn't tell you anything. Then 3, the document in question was marked confidential without prejudice provided for purposes of settlement negotiations only. That was the question put to me by the Master of the Rolls. It was therefore sent and accepted by the parties' English solicitors on those terms, which were terms of English confidentiality and privilege. Again, that may be so in relation, but the question is, to what then? What was the scope of that agreement? How did it interplay with 408? No mention of 408. There's no analysis of how it interplays. It's just, well, if you use those words, you can ignore everything else. And that is a theme of Ocado's submission. They just don't grapple with 408. And these are their grounds of appeal. And then fourthly, the judge should have found that the parties' repeated labelling of their email and written communications as without prejudice strongly supported Ocado's case. But to the extent of high probability of this succeeding at trial, that you simply sidestep 408.
I mean, are you doing any more, really, than repeating your basic submission, which is that even if it was agreed that this document would not be used for any other purpose, the reference to 408 brought with it the right of the American court to decide on admissibility, and there was no agreement that the English court should have exclusive jurisdiction to decide that question when it applied to American proceedings. Yeah. And in those circumstances, an injunction is inappropriate, whether it's looked at as an anti-suit injunction or not. Yep. You say there's no basis for any agreement between the parties on these materials that the American jurisdiction was excluded. In fact, you go further and say the American jurisdiction was agreed upon because of the reference to 408.
Yes, but
I mean, you're saying the same thing several times in different ways.
Slightly different, my lord. Paragraph 6 is the case against me if the high probability test succeeds. And what's said against me is if the high probability test is appropriate, Ocado still win because the court can be satisfied that there's a high probability that they're right. Completely right.
You say obviously not, because obviously, once you agree 408 applies,
I agree.
You agree American jurisdiction.
And that really is my only point on 6. 7 is important because it raises a point that has been said against me. The respondent didn't contest that under English law the document could therefore not be deployed in foreign proceedings unless one of the exceptions recognised by English law applied, and no such exceptions did apply. Now, we argued exceptions before Judge Hacon. It's not correct to say that we didn't do that. In fact, we put it every way. I'll just summarise it for you. It's in our written submissions at some length. And it raises some serious issues, which are, firstly, whether the protection is engaged at all. Because on the basis of Lord Justice Hoffman's decision, as he then was in Muller, this is not about the facts of the documents themselves. And he said the public policy only applies if you're contesting the factual content of the documents themselves, and that if it doesn't engage that, the public policy doesn't apply. Now, I would say that's a very difficult issue and it hasn't been followed, but we put our case in different ways. In Muller, 2 of the judges decided on waiver, and one of the points we made before Judge Hacon was, if the WP rule applies, then there has been waiver. And the reason there has been waiver is because you cannot advance a claim which cannot fairly be determined without reference to without prejudice privilege. And if you do that, you waive the privilege. That's one of the grounds. We call it 6A, I think. We also raised the ground of unambiguous impropriety, because our submission was this was unambiguous impropriety. Now, this is an issue that is raised on the appeal. I will take you very briefly, actually, to what we said below, because I don't want you to just take it from me that was what we argued, but it was very firmly put in by us, and it's in the supplemental bundle, tab 48, at page 313, paragraph 108. And I'll just take the court through that very quickly. Our primary position is 108. Our primary, sorry, it's page 313 of the electronic bundle and the hard copy bundle. So we said it didn't arise because it was 408, not WP. But if it did, this was our position. 109, assuming the English laws are without prejudice apply, they wouldn't exclude the admissibility. And then we set out a 110, the starting point being regard to the public policy underlying the rule, and that exceptions will be recognised where justice clearly demands it. And then we go through, and I'll just highlight a couple of points, but I mean, we set it out in some detail. 6 lines down on 111, Autostore therefore wishes to rely upon an unambiguous statement that it made during the course of discussions to meet Ocado's plea of equitable estoppel, and then you can see the next sentence. In the footnote at 66, we say that on one view of the decision of Lord Justice Hoffman in Muller, the issue is unconnected with the truth or falsity of anything stated in the negotiations, and then it falls outside the principle of public policy, protecting without prejudice communications. In that sense, the issue is not an exception to general rule. The issue doesn't fall within it. And then, over the page, we rely at 112 on the exceptions 4, 6, and 6A. So those exceptions 4 and 6 in Unilever, and 6A in the recent decision of this court in Berkeley Square. 113, exception 4 is unambiguous impropriety. And then 115, exception 6 is applicable here. And exception 6 is Lord Justice Walker in Unilever, page 115, bottom of the citation under 6, where you see the reference to Lord Justice Hoffman, the issue is one unconnected with the truth or falsity of anything stated in the negotiations, and therefore falling outside the principle of public policy, protecting WP communications. The other members of the court agreed, but would have also based their decision on waiver. And then if we go over the page, that is explained in our submissions at 116, 117. In Berkeley Square and Lancer, this is all an analysis of what happened in Muller. Better treated as a case of waiver than a case falling outside the principle of public policy. The waiver in Muller's case comprised the claimants putting in issue the reasonableness of their conduct in mitigation. All 3 judges in the Court of Appeal considered the plaintiffs couldn't assert the reasonableness of their settlement, whilst at the same time claiming privilege for the document through which it was reached. And the same applies here in 117. We say exactly the same. What you can't do in a submission on the basis of the law is to put in a claim which can only be fairly decided by reference to privileged material. If you do that, you waive privilege. So I'm just showing you that because that's where we put our case on exceptions, but we do rely on 3 exceptions, and we did before the judge below, and I don't understand why it's said against me that we didn't, but there we go.
To be clear, I don't think I did say that. I said
Right.
he did run it. I said the judge didn't make a finding on it, and there's been no respondent's notice. That was my...
Right, well, it's in which case, I accept what my friend says. It's not very well worded because of what it says at the beginning of the paragraph. The respondent didn't contest. I understand that not contesting applies to everything up to the comma, and then but not to a no such exception did apply. So it's a matter in the appeal. We've raised these exceptions. We argued them below, and we had 3 bases on which we did.
What are you saying? Where are you reading from?
It's paragraph 7 of the grounds.
Right.
Which start, the respondent didn't contest that. And what I understand my learned friend is saying, didn't contest that, is up to the comma, and then the comma, they accept we did contest that.
And I don't understand, I'm afraid.
Well, that's because I think it's difficult to understand.
No, but even if you did contest that an exception applied, where's your respondent's notice about it?
Well, because this is a matter that rises on the appeal, because they were saying that we didn't contest it below, and therefore what they say is, in the circumstances, the judge ought to have held that the merits of the case was plainly in Ocado's favour. So,
but you're saying the judge ought to have held that the exception applied under the without prejudice rule.
Well,
and that obviously required a respondent's notice.
I don't accept that, my lord. They are saying that it follows from the judge's conclusion that you have to show an exception and no exception. The judge didn't conclude that no exception applies, and they say it follows that they succeed on the appeal. And in my submission, it doesn't follow, because the matter was argued. They've put the exceptions in issue. They had to grapple with them. It's their conclusion on their appeal. That's why we've carefully put in those matters in the respondent's notice that haven't been raised in the appeal. This is something they've engaged in their appeal, whether the exceptions apply or not. I had understood that, we had, on our side, had understood that as a statement. It wasn't argued below, because it says the respondent didn't contest that. And I've shown you that we did contest that. So what they can't do on the appeal, my lord, is to say that you can simply, it simply follows that the exception isn't relevant. They say the exception didn't apply, and that's always been contested, and it's contested within their appeal. Paragraph 8, what they there say is the judge should have found the respondent's case entirely based on the unilateral oral statement made at the third meeting, which I've addressed that before, would have required them to prove that Ocado had waived their rights under English law in respect of the document by that unilateral oral statement. Such a waiver was not alleged, and requirements weren't even arguably made out. Waiver was expressly disavowed immediately after the reference to Rule 408. Now again, we don't understand that, because it presupposes that the without prejudice rule applies to the ITC proceedings. It presupposes that, and then it says, well, there isn't a case, and it hasn't been waived. It simply is identifying what the issues are, whether it's both, whether it's one or the other. It doesn't take matters further at all. And this is all in the context of the ground of high probability of success. So it's the reason I'm dealing with it in this way is because I'm meeting the case against me that it's said that even if the test is high probability, it's been made out. And this is all based on statements such as the exceptions weren't contested, which they were. I'm sorry.
Can I go back to your suggestion that the question whether the exceptions to the English without prejudice rule might apply is in play in the appeal?
Yes.
I understand
Yes.
why you say it was in play below. You've shown us your skeleton argument to that
Yes.
effect. I don't see anything in the judge's judgment which addresses this question at all, one way or the other.
No,
What the judge's judgment says at paragraph 68 is, I've reached a view that if there were to be a trial, the issue as to what was decided regarding US matters is an open question.
Yes.
He says nothing about, even if it were governed by the English without prejudice rules, there's a further question about whether any of the exceptions applies.
Yes.
Now, I think you accept there's nothing in the respondent's notice saying he should have upheld it on that ground as well. Nor is there anything in your skeleton for either of your skeletons for this.
We cross-refer. So what we do is we refer back to our submissions.
Where do you do that?
I'll get you a reference in a moment, but we do that. I know that because I looked up the reference myself. It's para 67, I'm told, of our reply, which is, I think, core tab 11. Yes, there we are. So, yes, we note yes, it's a reply to the appeal. Can I just, before I show your lordship that reference, can I just answer your lordship's question? It is not in the respondent's notice, we accept that, but it is a consequence of paragraph 7 of the grounds. And what we say in 67, which is page 155, finally, we note in passing that Ocado don't appear to be pursuing paragraphs 7 and 8 as ground 2 of their grounds of appeal. They're right not to do so. At the inter partes hearing, Autostore did contend that if the English without prejudice rule applied, then so too were one or more of the exceptions to that rule. By running a case in the US ITC that Autostore made statements that led Ocado to believe that the US patent were not infringed.
Well, I've read what you say there, Mr. Flynn, but,
Yes.
but I have to say I'm still perturbed by this because I think applying the usual rules in this court, if you wanted to say, even if the judge was wrong on it's an open question as to what the reference to 408 means, and the court concludes that it was, with a high degree of probability or whatever the test is subject to the English rules without prejudice. Nevertheless, we have an argument which can't be resolved at this stage that one of the exceptions applies, and I don't think you've done that.
Well, can I explain what our position is?
Yes.
Because your Lordship's quite right. It's not in the respondent's notice. I can't rely on it for the purposes of a respondent's notice. But what is said against me is paragraph 7. So that was firmly put in the appeal, which is if the high probability test applies, the respondent didn't contest that under English law the documents could not therefore be deployed in foreign proceedings unless one of the exceptions recognised by English law applied, and no such exceptions did apply. They need to prove in the appeal that no such exceptions did apply.
Well, isn't it for you to make out that there's an exception?
No, because that's their case.
No, but if I say this document's without prejudice, and you want to say, well, I agree it's without prejudice, but nevertheless we can put it in because of unambiguous impropriety, it's been used as a cloak for fraud, etc. Isn't it for you to make out an exception?
Can I? We're not. I totally accept we don't put it a response notice. I'm not suggesting that we do. But the case against me is this: that the judge had to reach the conclusion, if the test was right, that there were no exceptions did apply. Now that means that that issue is engaged, that no exceptions apply. That's their case. They've put in issue whether the exceptions apply or don't apply, and we did contest them, and therefore it's not. One can't take the view that we didn't. We weren't advancing a case that the exceptions applied, which is what this implies. We did advance at that, and so as part of their appeal, they need to grapple with both because it's their case that no such exceptions apply. So in my submission, it is a matter that arises on the appeal because of the way in which they have put their appeal.
Well, even if it does,
Yes.
you have made your points about it.
Yes.
And time is running on.
I'm quite right. Your Lordship's quite right. Because this is very much at the tail end.
It is really a rabbit hole.
It is, but I was asked the question in my defence. So
No, I'm sorry to say, Mr. Flynn, my view about this case is that either you're right or they're right. And if you're right, you've made it very clear what your point is
yes.
on really sovereignty and American jurisdiction and anti-suit injunctions, and we understand all that, and exclusive jurisdiction. And I understand very clearly also what the other side say. Now, going through the grounds of appeal, which really just repeats all that, doesn't really add to the price of tea.
If it's not helpful to you, I'm simply trying to do it as quickly as I can.
Well, but we've got to the nub of it.
Yeah.
I mean, you may want to say something about the balance of convenience, but I think you've said that too because you've started with it. I think you do need to move on to your respondents' notice points at some fairly early stage.
Can I quickly just say something about Denny Brothers? Because I know that was in your Lordship's mind. So, in fact, I won't take. Can I give you the references?
But your point on Denny Brothers is that was a case where there was an exclusive jurisdiction.
It's not just that. There was an exclusive jurisdiction clause, and there was no reference to the equivalent 408. So it was a completely different.
Yes. So you'd give us the references.
Yeah, well, I'll quickly show you. From the head note, you see there were 3 categories of information: without prejudice, settlement agreement, and mediation materials. The settlement agreement was expressly governed by English law and exclusive jurisdiction. You get that at the top of page 278. So that's why the issue didn't arise in that case. The judge also said at 884, very strongly arguable and indeed probable that the WP communications are indeed governed by an implied agreement. So even in Denny Brothers, the judge wasn't applying an American cyanamide serious issue. He was applying a stronger test, very strongly arguable, Page 886, he says a good deal more likely than not that the use of the settlement materials in US proceedings would be a breach. And then at 887, he says probably at least that the use of the mediation agreements would be a breach of the mediation agreement. And then at 888, he says a major concern, even if not the only or conceivably the primary concern, was the settlement of the English litigation. It must be very strongly arguable that the question of whether such negotiations took place under the aegis of the contract is a question of English law. So it's distinguishable here because the written agreements, as well as the WP materials, conferred exclusive jurisdiction on the English court, expressly stated English law would apply, and then against that background, it's unsurprising English law also was found to be strongly arguable to apply the WP materials. In addition, at the time of the WP negotiations, the only proceedings in contemplation were the English proceedings. So very different here. So 3 grounds, really. So we say that it's very difficult to see how Ocado can rely on a decision in that case. On prudential, I'll just very quickly say...
Just before you leave, Dennis, I know you want to get on. I understand that there was a written settlement agreement which contains an exclusive English law jurisdiction clause. But as you referred to, there were 3 classes of material. The first class of material was about prejudice material, and there Mr. Justice Lloyd says, I'm prepared to proceed on the basis it's very likely there was a contract, it was governed by English law, but he doesn't say, and that contract had an exclusive jurisdiction clause.
He doesn't.
Because that's not the sort of thing you imply.
No, he didn't, my lord, but in my submission, 1 is enough. That's the answer.
I see.
You've got your exclusive. Once you've got your exclusive jurisdiction clause, that's enough. You don't have to go through everything. That's the distinguishing factor.
I see.
That's what it's.
Is it not after the event, the exclusive jurisdiction clause?
No. Well, there's a settlement agreement. It's in the it was in the settlement agreement, the exclusive jurisdiction.
Yes, after they'd produced the without prejudice materials.
Yes, I think that's right.
So how can it sweep up the without prejudice materials?
Because you can agree subsequently to exclusivity in relation to the settlement agreement and what went on before. It's your lordship's right. It does. There isn't. There are 3 elements. The exclusive jurisdiction clause is only in the settlement agreement. I totally accept that. But in my submission, that's why it wasn't argued. It wasn't dealt with because 1 was enough and there was exclusivity. So it wasn't an issue in that case. So, but your lordship is right. On prudential, Lord Justice Chadwick, what Lord Justice Chadwick was saying was if a party relies upon an implied contract, what Lord Justice Chadwick was dealing with was whether public policy is sufficient. And he said it wasn't sufficient, you had to find a contractual agreement. And you could imply one from the words without. Now here, you have not only the difficulty of an implication, but you have the implication in circumstances where there's Rule 408. So it's not the same at all. And that was what he was getting at. I do accept that he says, in passing, applies the normal test for an interim injunction. I think he says you've got to show to us whatever the standard is. He doesn't say high probability in that case. Absolutely, he absolutely doesn't. But that wasn't the focus of his attention. His attention was on the contrast between contract and public policy.
I mean, it seems to me your case really turns on the analogy with the anti-suit injunction. Once you have agreed that 408 applies, if you agree that the questions of US admissibility will be decided by the US court under the US rules, then you say it's equivalent to preventing that court having jurisdiction. And if you're right about that, I mean, you did start by telling us this morning, Mr. Flynn. I know we shouted at you a bit, but you did start by telling us that, and that does seem to be the nub of your argument. And if you're wrong about that, obviously, and the rubric overtakes that agreement, well, then you're wrong. But it has to be considered in the context of what 408 means.
I'm sorry, Mark. Yes, although the question is, in what way am I wrong? Because there's no case in my submission, apart from a case that means that 408 is never considered. So there is either, or there is both. Now, if it's both, the case against me is the judge never...
No, you made that point this morning too. You say, when I put the point to you several times, yes. You said, if you're right, 408 is nugatory, I think you said, and has no consequence at all, and that's your case. That's why you say my point is wrong.
Yes, because, and also I don't see how we get to a position where I'm wrong in that sense on an interim application.
Well, you might be if it was absolutely clear that what the meaning of the contract was that you would never refer to it under any circumstances anywhere, notwithstanding the reference to 408.
Exactly, and what that interestingly comes back to in my submission, quite aside from my points on anti-suitors, what's the test for that? If it was that clear, high probability is the obvious answer to that question. If it's a high probability, one keeps coming back to that issue. It doesn't go away. It comes back in. It's not just a serious issue on that. Your Lordship put to me, if I'm wrong, to what standard would I be wrong on an interim application? It comes back to high probability in my submission. So I'm going to try to be, sorry, I'm trying to keep to your Lordship's admonition. Ground 3 is...
Ground 3 was scarcely developed.
Yes, scarcely developed. I think I'll probably then, in that case, not be take it very quickly, or if at all, actually. The short point is that 408 was treated by the parties as broadly equivalent to the without prejudice rule in the US. It's obvious why. I mean, the parties treated it that way. When one reads the 408, it's similar rule. It's not the same, but it's very similar. Ground 4, balance of harm. I think I've said what I want to say on that. So let me just see. I've been so. Yes, just very quickly, I'm asked to remind you. So summarising, in relation to the without prejudice agreement, it was varied by reference to the US law discussions in relation to 408. That distinguishes Denny Brothers alone. You can't imply an agreement in the face of 408 against me. There was no no similar implied term, no similar difficulty in Denny Brothers. I think that's it. So then I should go on to my respondent's notice points, which I can take quite quickly. We raised five further grounds on our respondent's notice, and I'll deal with that as quickly as I can. We've put it all in writing. Each of those are additional alternative reasons for upholding the judge's decision below, and all 5 of those are properly respondent's notice points. So they're additional or alternative reasons for upholding the judge's decision. Of the 5, only one of them did the judge reach a conclusion, and that's section 12.3 of the Human Rights Act, 1998. And it's not right for Ocado to say that this court will be revisiting the judge's evaluation if it considers the respondent's notice point.
Well, you say Mr. Justice Butcher was wrong and Mr. Justice Carr was righter.
Yes, I don't think we have to say he's wrong. I mean, on the facts of the case, one can see what was going on. It was a financial information within private individuals for personal purposes. One could see why he took the approach he did. We say, actually, insofar as he went beyond that, what he said was obiter. This only arrived.
You also say, I think, that this document gets into the public domain if it's deployed.
Yes.
And therefore, it is a question of 12.3 being engaged, even if it gets into the public domain in America.
Yes, or even
does it get into the public domain? I thought the evidence was that
there's protection regime. So that's it's not exactly accurate, my lord, but it is. The issue of principle does engage with whether documents can be provided to the public as a whole. In this case, it will enter into a regime within the ITC, which is not the world at large. So it isn't quite the same.
Right. Okay.
But you say publication to the court is a form of freedom of expression.
Exactly, and that engages a different point, as your lordship puts it very well, which is this is disclosure to the court. So there's a different type of public policy as opposed to the world at large. This is about engaging the administration of justice. So other issues arise.
Can you remind me what the territorial scope of the Human Rights Act is?
I will be reminded that I can't remember.
Because this is a Norwegian company exercising its freedom of expression in America.
Yes.
But an English court seeking to restrain or being asked to restrain that. How does the Human Rights Act apply to that situation?
Well, it's governed by English law. So it will be an application of English law.
Because it's an English court.
English court and English law. So it incorporates into, unless there's any reason Yes. Okay. Yeah, I was going to take you to the provision anyway. Apparently, it's in the answers in the provision. Just like the first point taken against me is yes. So I was just going to say I think the court accepts the aim of the application for interim relief is to prevent the ITC from knowing what happened within the meetings. And we say that's plainly a restriction on Autostore's right to impart information without interference by public authority, regardless of frontiers. Regardless of frontiers. So we submit that it applies, once it's engaged, it applies worldwide to everyone. And if we could just look at that, it's Article 10, it's in JA1, tab 2, page 5.
But there is authority. I understand what you say about the terms of the article itself, but there is authority on the territorial application of the Human Rights Act.
Yes, there may be. I'm not sure how. I'm sorry. I'm answering this off the top of my head, but I'm not sure
I
how.
have in the back of my mind degrading treatment of prisoners in Basra.
I can see that, but this isn't really extraterritorial in the sense that it's an English injunction that will restrain the parties under the jurisdiction of the English court from doing something abroad. It's not, can you apply it to a prison in Basra in that sense? It's not the same question.
No, but what I was thinking was that the expression which you want to have the freedom to publish is in America.
It is, but the restraint would be
here.
Yeah. So one can see that would be different. I have to say, that no one's raised that perfectly, but I'm not objecting to it in any way. So if you take my answers in that vein, but I think that would be the answer, which is that it's about a restraint emanating by reason of the injunction. It's not about simply the Human Rights Act applying to territory.
But again, if you're right, you don't need this.
Yes. Well, if I'm right, I don't need it. Absolutely. These are all respondents.
And in any event, what it leads to is a test lesser than high probability.
Yes.
It leads to effectively balance of probabilities,
yes.
More likely than not.
Yes, more likely.
And I understood Mr. Purvis to accept that given this is effectively determinative, we're in any event to look at the merits. And
your Lordship's right. I think the only problem was they never said it was about a balance of probability test. We never got the answer, but you're right. They seem to accept it's more than a serious issue, but to the degree to which it's more, we don't know. And the only way of getting to the answer is by... I can take it very quickly. I mean, we have set it all out in writing. If you look at the first point, is that the wording itself, everyone has the right to freedom of expression. This right shall include freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. So the wording itself is very broad. And we say there are 4 reasons why the judge erred. Firstly, this case does engage the Article 10 rights because it affects our right to freedom of expression. The case can be distinguished from Albury. We don't say it's wrong, Albury. Within the confines of that decision, it's perfectly understandable on a common sense and a legal level, but it was a case of disclosure of information for the purposes of furthering the party's financial interests, rather than the proper functioning of the judicial process, which is what we have here. There was no basis for distinguishing S&A. On the facts, S&A is much similar to this case. And there is an oddity, which is the approach taken by the judge is contrary to authorities on the public interest defence, which requires that any restriction on the right to freedom of expression must be proportionate and limited to what is necessary. And it effectively limits the protection in Section 12.3 to the world at large. And if you're more cautious and only disclose it to fewer people, you're worse off, which doesn't seem to make much sense. So, and we say the answers to those points don't bear scrutiny. I'll quickly run through them. They say that we haven't cited any authority for the proposition that freedom of expression includes the right to impart information. Well, I've just shown you Article 10. It's in the wording of the statute itself. They say that what we say is contrary to the reasoning of Butcher in Albury, but we don't accept that their analysis of Albury is right. I'm not sure it would be helpful for me to take you through the case. I was going to do that.
Well, you've just told us why you distinguish
Yes.
it. And you distinguish it because there the financial interests of the parties were being advanced by the use of the document, which is quite different from this situation.
And if you look at S&A, that was an applicant trying to prevent the respondent from relying on information in proceedings before a Massachusetts court found jurisdiction. And in S&A there was a written NDA with an exclusive jurisdiction clause in favour of the English court. Again, exclusive jurisdiction clause. And that was why Mr. Justice Henry Carr was considering the matter at all. And he had no difficulty in applying section 12.3. And we say it was correct to do so. And then Aubrey, that was obviously nothing to do with disclosure of information to an overseas court, and it was concerned with internal misuse of confidential information. So I don't think I need to say any more. We've put everything else in writing. That's that. Second point is failure to meet the threshold test in our respondent's notice. I think I've said everything I want to say about that during the appeal. I don't need to say any more about that. Harm and delay, I have said this, I have made my submissions on harm and delay. I just do want to reiterate one point, which the court may not be fully apprised of, but we deal with this in paragraph 57 of our respondent's notice skeleton. And that is that Ocado knew of Autostore's intention to rely upon the disputed document from the 8th of March 2021. They delayed nearly 3 months in bringing the application. Now, had they acted immediately, it would have been possible for the point to be resolved in good time before the US ITC trial.
Could have been a trial.
Before the deadlines fell due.
Could have been a speedy trial.
It could have been a speedy trial, absolutely. You could have had a fine law. We may have had the same issues about why it should be here, but yes, this court could do that in that sort of timescale. Now, we say that is a very important factor. It wasn't the first time that they tried to delay the ITC trial. We say that is the backdrop to all of this. And it's no answer to say, oh, well, the lawyers didn't know. They told Mr. Justice Hacon that the lawyers didn't know till the 20th of May, I think it is. But the client themselves had known since the 8th of March. And that is one of the grounds of full and frank disclosure that we rely on. And they don't deal with the fact that Ocado had the knowledge when it received Autostore's response to the interrogatory. And what they do say is that it wasn't provided to Ocado's in-house or UK legal team. But that doesn't matter. It's Ocado's knowledge that counts. They also say that the disclosure of the disputed document, that was an inadvertent disclosure. That's their evidence. But that isn't what Mr. Ayrton says. He doesn't go that far. And there's no evidence from Ocado's US lawyers on the point as to what happened in the US proceedings. Mr. Brinkman, who is our US lawyer, gives evidence that the disputed document was produced by Ocado in response to a request by Autostore. I won't take you to it, but it's Mr. Brinkman's first witness statement, paragraph 15, supplementary bundle, tab 28, page 168. And he also confirms that to date no request has been made by Ocado's US lawyers for the disputed document that they disclosed within the ITC to be withdrawn on the basis that it was disclosed by mistake and was in fact a privileged document or otherwise protected. He deals with that in his second witness statement, paragraph 8, supplemental bundle, tab 41, page 228. They also seem to say that there was a relevant objection taken to the disputed document at the deposition. In fact, the only objection taken to Mr. Limbo answering questions on the document was one based on attorney-client privilege. That's also dealt with by Mr. Brinkman in his second witness statement, paragraph 10, supplemental bundle, tab 42, page 229. So, as Mr. Brinkman explains, whilst Ocado could have asked for the document to be withdrawn from the record on grounds of privilege, they didn't do so. And indeed, Mr. Beeney was content for it to be marked as an exhibit. So we say none of the points made by Ocado has any merit, and there is no excuse for their delay. That brings me on to full and frank disclosure, which I will deal with as briefly as I can. We've put it all in writing. It's dealt with at paragraph 61 of our respondent's notice skeleton. And essentially, there are seven failures. They include the false statement as to when Ocado first knew of the issue, obtaining a super injunction in the sense that the order prohibited the ITC judge or anyone else from even knowing of its existence, which we sought clarification on and weren't given. Thirdly, the failure to explain the pre-action correspondence to the judge at the ex parte. Fourthly, a failure to identify the relevant principles. Lordships, the court will see from the submissions that there are some complicated and difficult issues here. It wasn't approached with any of that in mind. And we say there was also, fifthly, no fair presentation of the facts. Sixthly, a failure to explain the relevance of Rule 408. You'll see even on the appeal it's really been sidestepped. It was sidestepped before Hacon. It's not mentioned in the pleading. It's said to be, the relevance of that is not really taken on board at all, and that should have been explained to the judge on the ex parte. And then finally, a failure to explain what exceptions to the English without prejudice rules might apply. I've told you what they were. Obviously, when you're applying for ex parte relief, it's your obligation to tell the court what the party would have told the court had they been there. And that would have been identifying which exceptions might apply. And I've explained to you the underlying issue, which was the presentation of the equitable estoppel in the trial. That wasn't done. And now, Ocado doesn't attempt to in my submission, those are serious. These are not make-weight failings. They are serious failings, particularly in relation to the delay. Now, one would have expected, in response to that there would be an apology and an explanation. But there wasn't. There was never any apology, no sense of contrition whatsoever at any stage.
Could be, Mr. Flynn, because they think that if they're right, they would have the injunction anyway, despite having failed to make full and frank disclosure because it was such an obvious case for an injunction. And if they're wrong, it doesn't matter.
Yes, except that it's. I think I understand that, but then one would never have full and frank points. The point is here is that the judge wasn't given a fair presentation of what happened. The delay point, for example. For example, the delay. Let's say they are otherwise right, but they didn't. They told the court something which was untrue, which was they only knew about it on the 20th of May.
Well, they may not have. Maybe the lawyers saying it, and they didn't know about it.
Well, that may be the case, but there isn't an explanation as to what the client's knowledge was. There is only an explanation that the lawyers didn't know. Now, that's why in my submission, you're right. Ordinarily, it may just go with the ultimate result, but here in my submission, it is different. And no contrition at all. This was all absolutely,
I don't think this case has been marked by
No,
contrition,
it hasn't,
Mr. Flynn.
It hasn't, my lord.
No.
I'm sorry, my lady. Do you have a question?
No, I'm sorry. I was trying. It was just the remark that this case hasn't been marked by contrition.
No,
Sorry.
no. I understand that, but these are serious points. I mean, the delay in particular. You see that, my lord. It's in the context of what the underlying case is about the ability to defend ourselves on the equitable estoppel claim. And that we've set out the authorities that if you do find that there's been a failure to make full and frank disclosure, the ordinary course is to discharge the order. I won't take court to those. Yes, and there's the other issue is the super injunction. I mean, there are very strict rules about super injunctions. None of that was adverted to. The judge wasn't told that. The effective part of the order was put in a confidential annex, essentially a gagging order. And that and then the final point is the post ex parte hearing. We have a separate point on that, which is what happened after the order was made. And that, the court, I think, will have seen that. We rely on Mr. Justice Males's decision in Euroil. And actually, the order was so broad, we had to seek clarification. We asked several times, please can we show this to the judge in the ICC? Can we show the judge the order? And we didn't get an answer except, well, what context is it that you might be wanting to show the order to the judge? Now, in Euroil, the difficulties caused by the scope of the order was such that the judge considered that was sufficient to have the order discharged. And the other point that we have is, so the width of the order was so broad that we couldn't even mention its existence in terms to the US ITC. And then the other point that the court will have seen is that there were unjustifiable and repeated attempts to personally serve the CEO at his home address when the order had provided for service on the company, late at night, on a Friday night, when his wife was in the house alone. Now, on what basis could that possibly have been done? And it was coupled with the failure to give an explanation as to what the order meant. Could we even show it to the judge? So in other words, there was an implicit threat of contempt proceedings coupled with the service late at night, and with an order unduly wide. One only has to read the order to see the breadth of that order, that we couldn't even understand whether we could show it to the judge or not. Now, those in my submissions are further reasons why Ocado is not entitled to its order, even if, and I hope your lordships accept my submission, but even though I was wrong on the underlying case, the full and frank failures and the treatment of the order once it was given are all reasons for Ocado not to be permitted to have this injunction. And I'll just finally say, and what would be the consequences of that? They can take their case to the ITC judge and make their case, whatever case they want to make. to the ICJ judge on admissibility. It's not as if it's final for them.
Well, that's the balance of convenience.
Yes, it is, my lord, but that's what happens. That's what would happen if you accepted my submissions. They will try to persuade the judge they've got a contractual right to...
The sky will not fall.
No, it's far from it. They can make all their arguments. We're not going to prevent them making whatever arguments they want to the judge. And they can say whatever they like, for good, bad or ill. So, my lord, those are my submissions. I'm sorry I've had to take it at quite a pace, but...
No. Thank you very much. Thank you very much, Mr. Flynn. Yes, Mr. Purvis.
Can I just reply on the notice of appeal points, and then for Mr. McLean will deal with the respondent's notice points. I've got about 6 points I think I want to run through relatively quickly. On the merits, my friend consistently suggests that the reference to 408 in the minutes of the third meeting would be nugatory if we were right. Not so. As I have submitted, the rule of admissibility in the US federal courts applies regardless and alongside contractual obligations of the parties. Indeed, looking at the rule, as we can see, it has nothing to do with contractual obligations.
Well, it's certainly nugatory as regards documents produced under the rubric which you seek to have us interpreted as a have us interpret as a blanket prevention.
Lord, no, and that's what I want to explain. First of all, what it does, because it's a separate and freestanding way of objecting to evidence getting before the court, it makes clear that if evidence ever was sought to be put before the US federal court, by whomsoever it was advanced or attempted to be advanced, parties were agreeing it would be in any event subject to 408, plainly because these were compromise negotiations.
Well, once you agree that, you agree the US court should have jurisdiction to decide if the exceptions apply.
Lord, only so far as if one reaches the stage where the document has got it. Imagine a third party, for example, got hold of these materials and sought to deploy them in US federal proceedings. The parties would be shown to have agreed that these negotiations were indeed compromise negotiations covered by 408. So although they wouldn't be able to rely on the contractual obligations against a non-contracting party, they had the benefit of the non-admissibility rule.
I mean, the real question that I'm wrestling with, Mr. Purvis, is whether 408 can really be said to have been overridden by the agreement not to refer to the document save for settlement negotiations. And the analysis that Mr. Flynn has put to us is that what was effectively agreed by the amendment to the contract was that insofar as the document was necessary or required or relevant to American proceedings, 408 would apply. And therefore, that brings in his exclusive jurisdiction point, that means you're agreeing effectively US jurisdiction for that part of the proceeding, and it brings with it all his points about anti-suit injunctions, because we here would be saying to the US court, you can't even see this document because it's trumped by the words only to be referred to in settlement negotiations. And he says that's meaningless because it's that is giving far too much weight to those words and no weight to the agreement that 408 should apply to what goes on in the States.
Well, the agreement was that the documents couldn't be used, save for the settlement negotiations. That was the consistent agreement throughout.
And that 408 should apply.
The statement at the meeting made clear that, in addition, 408 would apply, and indeed 408 does apply.
What's the content of 408 applying? If if it can't be referred to under any, if no document in the negotiations can be referred to under any circumstances in the American proceedings?
In an excess of caution, not excess, as a matter of caution, it's very sensible to say, well, even if somehow this document gets before the US courts, we are all agreed that it is subject to 408 as a matter of admissibility anyway. So regardless,
well, that's a new point. I mean, that's a sort of,
well, that's what we say in our
belt and braces and other suspenders.
Well, this is what American lawyers like to do, and perhaps rightly.
But I mean, you
and I have given you,
just stand back for a minute, Mr. Purvis. Just help me.
Yeah.
I'm troubled by this. What happens is that there are two meetings to which the rubric applies, and then there are documents sent in that relate to American proceedings for the first time, and one can envision that the English lawyers get on the phone to Kirkland and Ellis and the other firm in the States and say, we're now going to talk about what might go on in the States. And somebody in the States says, oh my goodness, it's all quite different in the States and 408 applies. What are the restrictions on having this discussion? And they say, lawyer for one side or the other says, make 408 apply. Then it'll be okay because we understand that in America.
Sure.
Now, surely what it means is make 408 apply to the possibility of the document being used in American proceedings.
But not exclusively of the contractual rights that have always existed in relation to all these negotiations, including the sending of the document in the first place, which of course preceded the meeting.
But that doesn't matter, does it, if they agree something about how it's to be used later?
Well, why would it be that a party would be denying itself the right to prohibit the use of that material anywhere in the world as a result of the agreement not to disclose, the instance and any implied agreement, and replace it with an admissibility rule that isn't actually a contractual obligation at all and would in any event apply? I mean, essentially they're saying, according to the other side, just write off the agreement, just fall back on 408, which was already there, already exists. Essentially his case is, when that statement is made at the meeting, as far as US proceedings are concerned, you're writing off all contractual protection. Because frankly, contractual protection is not the subject of 408.
It's not quite as simple as that, I think, because nobody quite knew why anybody would be wanting to refer to such a document. I mean, we've looked at it, but it was obviously produced by Autostore in order to get a settlement of the putative American dispute.
Right.
And and you are the one who comes up with the 408.
Right.
Not the other way around.
Well, imagine, so far as Autostore is concerned, somebody had said, well, what if a third party gets hold of this document? What's going to be the position?
Do you know, Mr. Travis, the third party does sound like a red herring to me.
Well, we do get cases where, one's aware of disclosure applications being made in the United States to try and get hold of all sorts of information that may have derived from other proceedings. One can't be sure. But what our case has always been, that this was added to the reference at the third meeting, simply out of an abundance of caution, to make sure that as a matter of admissibility, whatever happened, there was a fallback where you could say, actually, 408 applies. Now, your Lordship may be right. Maybe it's unlikely a third party might get hold of it, but it's possible. That all might try to get hold of it. It's possible. But it's perfectly possible that one of the parties might put the document before the United States court before anyone had the opportunity to get an injunction.
Well, it's possible. But do you remember in argument this morning, my Lord put to Mr. Flynn the question about the the difference between an exclusive jurisdiction clause where you had promised not to bring proceedings in another country, and this agreement where you had promised not to refer to a document. And it was put to Mr. Flynn that there was no difference because there you'd promised not to bring proceedings in the foreign country, and here you'd promised not to refer to the document anywhere. But I think Mr. Flynn's answer to that, I'm not sure whether I'm quoting him correctly, was, well, they agreed that 408 would apply. That's the difference. They agreed that 408 would apply to the use of the proceedings in America. That can be the only relevance of having mentioned it. And that's different from exclusive jurisdiction.
Well, that's his assertion based on his case, that was the intention. But as I've said, we know the proceedings are going on in the United States. There is a law that governs the admissibility of documents in the United States that stands completely apart from the contractual obligations of the parties. And when one says, well, that's going to apply anyway, that is not excluding the contractual obligations generally that the parties are.
But can you say that it's clear where you have that bifurcated approach that you promised not to use the proceedings, not to use the document for any purpose, even if 408 allowed it to be used in America?
Yes, we say the promise was exceptionally clear in all the documentation. And the fact that 408 nonetheless still applied, which has got nothing to do with the contract, doesn't dent that at all.
But 408 does, on its terms, deal with the circumstances in which reference can be made to documents that were used in settlement negotiations, doesn't it?
It does, but it does not have anything to do with contractual agreements. It stands aside from any express or implied agreement of the parties. That is why it is very different.
No, I agree. I mean, I think what we're struggling with is the agreement, you say, is a blanket agreement.
Yes.
It's an agreement not to use the documents under any circumstances in any place.
Yeah.
And exclusive jurisdiction, England, effectively, has to be. And they say, well, then why did you refer to 408 in relation to the question of the use of the document?
Yes. Well,
and the answer, they say, is, well, it's got to be because you intended the exceptions in that rule to apply if it was going to be used in America. And then they go on and say, and furthermore, you're actually railroading the American jurisdiction without an exclusive jurisdiction clause at all, only the implication that there might have been intended to be an exclusive jurisdiction in the US.
And we're saying, in any event, whatever happens, let's say we can't get an injunction against you in time, somehow it gets into the US proceedings, either party saying that to the other. In any event, you've still got to get over the hurdle of 408, because that's going to stand as a rule against the admissibility of this material, regardless of the contractual obligation not to have put it in the first place. So let's say the US court, for whatever reason, neglected to be prepared to enforce the agreement. We've still got 408 to fall back on. That's what we say.
Is it any more complicated than that your case is that 408 is in addition to the contractual protection, and Mr. Flynn's case is it's in substitution for it?
In substance, no. I agree entirely.
But can it logically be in addition is the question I'm asking.
Well, what I'm doing is trying to say actually there is a coherent reason, as well as caution generally, that lawyers sometimes put things in that are unnecessary. But there is a coherent reason here because one never knows.
I mean, you started this morning by saying it was really unnecessary, but the point is, it seems, at least on one analysis that Mr. Flynn has put to us, to actually be inconsistent with the blanket.
That's what I'm saying to you. It's not inconsistent because it exists alongside and in addition to your contractual rights. and there is no reason on earth why the parties wouldn't provide that degree of protection, so far as the admissibility of the material is concerned, continue to exist.
It's never going to happen if there's an absolute inhibition on them using it for any purpose whatsoever.
One would hope that. One would hope that it would never happen. But of course, one knows
So it
in
comes
reality...
back to my lady's belt and braces.
Yes, belt and braces. One knows in reality it does happen. They've tried to get it in this case. If we hadn't got to a judge in time, maybe it would have gone.
I mean, the irony is that your side introduced it.
I'm sorry, my lord.
The irony is that your side introduced the idea of 408, not theirs.
Oh, well, it's... it is. And it's, we say, they've seized on a reference to an additional admissibility rule that's there to protect the parties anyway, and built it into this enormous edifice that it's a completely different agreement now. It's a distribution of jurisdiction. It's a distribution of choice of law.
Well, no doubt if we had more time, we could have a very interesting argument about contra preferentum.
But it's not without interest the way they phrase it.
Yes.
The meeting was a continuation of a confidential and without prejudice discussions
Yes.
between Ocado and Autostore, and that any US law discussions were to be governed. It's that same word, discussions.
Mhm.
As Master of the Rolls has said, I think this concept of the third party is a red herring, certainly in the context of that description. So you've got your confidential and without prejudice discussions, and then you have the US law discussions.
Yes, which are to... I'm sorry.
No, you carry on.
And those discussions have a separate degree of protection as well, in terms of the admissibility of any of that when it comes to...
But it's inconsistent.
US.
It's inconsistent. You cannot have a blanket inhibition as being consistent with the ability to use the document in the case where the exceptions apply.
I would agree with my lord if that's what the admissibility rule was.
Well, go and have a look at it.
But one's a contractual restriction and one is a rule of admissibility. And it is not unreasonable to say, if I can put it this way, if the material were to be put before the court, brackets, in breach of the obligations, in any event, it is protected by the rule against admissibility under 408, insofar as that applies.
Okay, well, I see that point, yeah.
And that really is what we say. It is not, it's not inconsistent, it is an extra degree of protection which may or may not be necessary. I mean, we would accept if it was truly inconsistent, so that it was impossible to imagine how both obligations could stand together. That would be a true inconsistency. That would be a perfectly good point to take. But this is not one of those cases. This is a case where the obligations can quite properly stand alongside each other. They are of a different form, and one can exist even if you have proved unable to enforce the other. Can I just mention the exclusive jurisdiction point that my learned friend made a lot of? It's never been the case that an exclusive jurisdiction clause is necessary to enable an interim injunction of this kind to be granted. And that certainly was not the case in Instance and Denny. The implied agreement, which is the key area of the authority that we're concerned with here, related to the without prejudice materials that were exchanged long before the settlement agreement, which was the only agreement that had an exclusive jurisdiction clause. And the decision of Mr. Justice Lloyd in relation to the implied agreement, which is what we're relying on, had absolutely nothing to do with exclusive jurisdiction, and he never says that the English court has exclusive jurisdiction over that agreement.
No, but you might think that when you subsequently agree that there's exclusive jurisdiction over an agreement, it also means exclusive jurisdiction over what gave rise to the agreement.
Well, it wasn't what gave rise, it was a different agreement, if I can put it that way. So
Completely different.
One was to do with the settlement of the dispute. The earlier agreement was to do with the exchanges of correspondence.
So the without prejudice materials did not give rise to the agreement.
I'm not sure. I think that's right. I think there was an early exchange,
To look at it a bit
1991 to 1993, I think. And the settlement agreement. I'm not sure what the dates are.
Well, it's later.
Yeah, it's certainly later, but I don't think it's at all clear. But he definitely deals with the 3 points.
It deals with them as separate batches of material. The settlement agreement said you can't disclose the existence of the litigation or disagreement. It didn't expressly say you can't disclose them without prejudice.
No, I think that's why he had to deal with the without prejudice communications as a matter of implied contract. Otherwise, he could simply have relied on the settlement agreement to cover that as well.
I mean, obviously, your case is much advanced by instance, but it's not. The fact is, we're concerned here with. You said at the beginning, and I stopped you. The construction of an agreement. We're concerned with the interpretation or evaluation of what that agreement was, which may or may not be comparable with instance. And to me anyway, the really significant point about the exclusive jurisdiction argument is how can you agree exclusive jurisdiction if you impliedly agree that the American discussions, the discussions about the American dispute, will be governed by something that only the American court can be implied to be expected to give effect to, namely Rule 408, because that's presupposing there will be American proceedings and an American decision.
Well, the reason for that is that will always be the case even in an instance in Denny or any such situation where you have agreed contractually to restrain, to not to use information for any purpose.
There was no Rule 408 in instance.
There would have been. I mean,
they didn't mention it. They didn't say we're discussing the American proceedings and Rule 408. I mean, one of your strongest points, Mr. Purvis, was that their argument initially was that if it was German proceedings, the equivalent rule in Germany would apply.
Yes.
Well, they didn't mention the equivalent rule in Germany, nor did you. So that's vanishingly unlikely.
Well,
but you did mention 408.
Yes, because American proceedings had reared their head. But the fact is, on our submission, we submit it's the right position. It didn't make any difference whether 408 had been mentioned or not. The position would have been exactly the same if 408 had been mentioned, not mentioned, or mentioned. Essentially what's happening, he's standing up at the beginning of the meeting and he's simply referring to the admissibility rules in the United States, which apply come what may. An instance in Denny, the US court would have had its own admissibility rules. Whether you mention them at some point in the course of the negotiations or you don't, in my submission, can make no difference. The rules exist, they're going to be applied, and all Mr. Ayrton is saying, we say, is that of course 408 exists. Of course, anything's always going to be subject to 408, but what he's not doing is writing off the fundamental contract between the parties.
It doesn't say that, as my lady's pointed out to you. It says that we agree that any US law discussions were to be governed by Rule 408 of the rules of evidence, i.e. the rules of evidence in the US to which US law and US courts apply, i.e. not exclusive jurisdiction.
Which is a rule of admissibility. It is a rule that always would apply. So he's simply stating...
Apply to what if the documents you're discussing can never be disclosed again?
Well, in the event that they ever got before the court. I mean, your lordship's suggestion is that when negotiating an agreement of this kind, one would always naturally assume that both parties would behave so properly in the course of complying with the agreement. One didn't have to provide any other any other possibilities.
I mean, Mr. Purvis, I always look at the realities from a commercial point of view. What seems to have happened here is that English solicitors were busy discussing English litigation. They were aware of American litigation in the background. They suddenly got to it after 2 meetings, rang their American attorneys. The American attorney says, for goodness sake, don't forget to mention 408, which applies here in relation to any without prejudice discussions. So they dutifully do so and record it, probably without ever having looked at it or understood its consequences.
Yes.
The problem with doing that is that they are therefore bringing in a non-exclusive arrangement. They are bringing in an arrangement which means that this discussion and the agreement reached is governed insofar as the American proceedings are American dispute is concerned by US law. Well, which is what the American attorney, your American attorney, obviously wanted by mentioning it to you.
Well, my lord...
I mean, that's the commercial, reality of what, judges, Mr. Purvis, are not born under gooseberry bushes.
Your Lordship, I think, has seen exactly what's going on so far as the US lawyers are concerned. They're saying we need to make sure at least that 408 is going to apply.
Yeah. The
argument is, does that mean that 408 is now the only thing that applies to these discussions, insofar as they concern the US, including documents that have already been sent under a different confidentiality regime? Or is it a reference to something which is an additional potential form of protection in the event that something goes wrong, or the event that these materials get before the court in any event? It is commonplace, we submit, in negotiations to provide fallbacks in case something happens that perhaps oughtn't to happen. But it certainly oughtn't to be held to prevent a party from relying on the agreement that was already reached, that he added a reference to a different form of protection that in fact already existed.
Yeah, well, I think we have that point, yes. I'm sorry I've spoken so much. I promise to shut up for the rest of the reply.
It's in many ways the crucial issue as to how one sees what was going on here. But in my submission, what's happening is an enormous edifice, as I say, is being built on a reference to a perfectly straightforward reference to a rule of admissibility, which in any event existed. And the idea that suddenly the entire jurisdiction over this issue is being reserved for all purposes to the US court, in my submission, would have come as a huge surprise to the parties if he'd said so at the meeting. It's certainly interesting that nobody picked up on it, and indeed that when Bristow's responded after the meeting on the subject of the US issues, and I've shown you that email, they didn't say subject to 408. They continued to use exactly the same language that has been used previously. And it's quite interesting to observe the dichotomy between what Mr. Brinkman says is his view of what must have happened. He says in his witness statement that after that meeting, the without prejudice rule didn't apply to the US materials. I can show you that at the supplemental bundle.
Well, Mr. Flynn showed us that earlier, didn't he?
I'm not sure whether you saw the...
I thought he said without prejudice didn't apply and 408 did.
I think he did. Sorry, my lord, you may well have done. It's supplemental tab 28, paragraph 25. He says the US discussions were not subject to the without prejudice rule. But of course, that's flat inconsistent with the email from Bristow's, who were actually at the meeting, which they sent after the meeting, which is at tab 14, which says, in respect of communications about the American proceedings, the same issues, confidential, without prejudice, and for the purpose of settlement negotiations only. Now, that, in my submission, demonstrates what's going on here.
Well, that demonstrates what Autostore were trying to restore. But Bristow's is Autostore's.
Yes.
Yeah, but it's you, Ocado, that introduced the 408.
Well, this is after the meeting where it said
No, I know,
was,
but I mean, you've agreed something. What I'm talking about is it wasn't them that was trying to rely on it. It was you, and you raised it. First off, we look at the minutes, which is the. Sorry,
right.
I shouldn't be doing this, but if you look at the minutes,
yeah,
the minutes said SA. That's Mr. Powell Gilbert, Mr. Ayrton of Powell Gilbert, and he says I want to be clear. He comes in, sits down, says, I want you guys to be clear. The meeting is a continuation of the confidential and without prejudice discussions we've had, but any US if we now come and discuss US law discussions, that's got to be governed by Rule 408. And they say, okay.
Well, they plainly don't, of course, because what happens when they write the email after the meeting,
Well,
they're
they
continuing
agree
to
now
behave.
that that's what they did agree.
I'm sorry, my lord.
They agree now that that's what they did agree.
Well, that is very difficult for them because quite obviously they didn't think that at the time. And that does make their position very difficult to my submission.
Right.
And for Mr. Brinkman to say plainly without prejudice no longer applied, and for, in fact, Ms. Cartwright to write days later in respect of the same thing, saying that these were without prejudice, is completely inconsistent. We submit that is the most telling piece of evidence in the case. Nothing had changed so far as Autostore were concerned. And if nothing had changed as far as Autostore is concerned, we can't have a new agreement. Quite plainly, there hadn't been a meeting of minds as to a change so far as the US discussions were concerned.
But that at least surely gives something for the trial to determine.
Well, it's the same. Your Lordship's got the material just as a trial judge would have the material. I suspect the trial would last the same time as we've spent discussing.
Well, except, I mean, if you're saying that paragraph does not reflect the agreement that was made,
no,
which you are.
No,
you're saying it's overridden.
Inconsistent with my learned friend's account of what the agreement was.
But you're still saying it doesn't reflect what was agreed effectively, because you're saying they went back to saying without prejudice and not to be referred to save in settlement discussions and confidential, and that was what dominated. So you're drawing attention to the fact that 408, which you tried to put in, is then taken out by them. I mean, this is a little bit confusing because, you introduced this, they're now relying on it, and now you can't agree as to what was agreed.
Well, we definitely can't agree as to what was agreed. But in our submission, you've got the objective materials upon which to decide what the agreement was. We say what they're now saying is flat inconsistent with all the correspondence, including, importantly, the response, one thinks of it that way, to some alleged change at the meeting. Yeah. Nobody thought there was a change at the meeting. It's notable that none of their evidence put forward from the people who were there, there was no evidence put forward from people who were there on the Autostore side to say, oh, obviously things have changed. And one can observe that in fact no one did think it had changed. This is Mr. Brinkman after the event, going back over 3 years later and saying, oh well, look at this, when his own solicitors plainly didn't think so. So, my Lord, that's what we say about that. I probably don't need to say any more about the instance and Denny point. My learned friend placed a lot of reliance on the suggestion that in order to win, we had to show that the English courts had exclusive jurisdiction. In my submission, there's no authority to that effect. Instance and Denny is contrary. Prudential is also contrary. There's no reference there in Lord Justice Chadwick's account of the jurisdiction to grant interim relief in a case of this nature, that the UK court needs to be shown to have been given exclusive jurisdiction over the point. I think
it's all bound up with the other point.
I think the point my Lord was putting to me was a slightly different point, which related to the agreement itself and whether in fact exclusive jurisdiction had somehow been agreed to be granted to a different court in respect of the US law. My learned friend was making, I think, a different point from that, which was that in order to succeed we had to show the opposite, that the English court had exclusive jurisdiction to enforce the contract. And we submit that makes no difference whether the jurisdiction is exclusive or not. You've got the jurisdiction, and as in Instance and Denny, despite the same point being argued there, that it should be left to the US judge, the court being shown to have jurisdiction and being presented with what the judge regarded as a clear case.
It's all bound up, Mr. Purvis, with what the agreement was. I mean, if you're right about what the agreement was, you're right, and if you're wrong about what the agreement was, you're wrong.
Well, yes, which essentially is what I said to you at the outset. This is a case all about the merits, and because it's the be-all and end-all of this dispute, we're effectively inviting this court to determine it on that basis. I should mention two other points. At the balance of harm point, what I call the second bite of the cherry point, is in our submission an illogical analysis. We should think about it this way in my submission. There is only going to be a problem if the US court allows the material in. Clearly, if the US court determines on the basis of its own rules and admissibility that the material is not going to go in the case, then it doesn't matter what we decide in these proceedings in the United Kingdom. So we have to proceed, so far as the balance of harm is concerned, on the assumption that the US court does allow the material in. And if that's right, then we're faced with a case where our rights under the contract, as we allege, are either going to be enforced or they're simply not going to be available to us at all. And the fact that we might be able to keep it out on other grounds is neither here nor there. This is all about the ability to enforce this contract. It's the same argument, in fact, that was rejected in Instance and Denny itself. My learned friend referred to the anti-suit injunction cases and said there was no reason advanced why this case should involve a lesser hurdle so far as arguable case is concerned. That's not right. We did advance. I did advance that case before you this morning. The reason is that the interference with foreign proceedings is manifestly of a much lower level if one treats it as interference with proceedings, than the cases that we were looking at, which involve either a direction not to bring an action at all, or not to be able to enforce a judgment which you have obtained, which effectively comes to the same thing. One is destructive of the cause of action and a right to take proceedings. The other is an issue with the ability to deploy a particular piece of evidence. In our submission, that is quite a different matter when one looks at the reasoning that underlies those anti-suit injunction cases founded on comity. One can see that the courts are concerned with what is quite almost explicitly an invasion of the sovereignty of the foreign courts. So I think those are my submissions, unless I can help you further on the notice of appeal.
Do you want to say anything about the exceptions to the English law of prejudice?
I think not much more than the points that I've already made. In my submission, on the usual "here asserts must prove" basis, these are propositions, if my learned friend wants to rely on them, that he would need to advance and establish. And if he wants to say that the judge ought to have found that our case had not been established to the adequate standard because even if we were right, they had a defence under one of the exceptions, that is plainly a further or other reason for supporting the judgment, which he would have had to put in respondent's notice. In fact, he did put in other reasons for supporting the judge's conclusion about our.
So you say it's not open.
And this, we say, it's simply not open to him to run. And I didn't really hear an answer to that. He seemed to be saying, well, there's
he said it arose out of paragraph 7 of your grounds of appeal.
Yes, and we say this is all about his respondent's notice. It's all about him attempting to support the judge for different reasons. And we say that's what's not open to him. At one point arose this morning, learned friend got very close to, well, we say he probably did, disclose rather more about the issues which we're trying to exclude than should have been done in open court.
Right.
Now this kind of thing happens from time to time, and it happened, I think, before His Honour Judge Hacon, and a direction was made that that part of the transcript be treated as private. And
Yes, well, if you agree amongst yourselves which part it is, we can do that. I wouldn't waste time on it now.
I'm not going to raise it now, I'll just mention it, and we'll try and agree it after the hearing.
Absolutely fine.
Great.
Good. Thank you very much, Mr. Purvis. Mr. McLean.
I see the clock. I'll try and do this as quickly as I can. I appreciate some of these points are of importance to the parties, but not, and some of them are legally important, but perhaps not so determinants of the appeal. For example, the debate between Mr. Justice Henry Carr in SNA and Mr. Justice Butcher in Aubrey is obviously of some jurisprudential interest and perhaps some substantive legal importance in other cases. In this case, perhaps as to the outcome of the appeal, not so. But your Lordships know from our skeleton argument that Mr. Justice Henry Carr certainly applied Section 12, we accept that. He didn't give any reasoning as to why. Mr. Justice Butcher, in a lucid and persuasive judgment, does set out some reasoning. He doesn't say that Mr. Justice Henry Carr was wrong to do what he did. And of course he wasn't bound to follow Mr. Justice Henry Carr as a matter of authority, but he would ordinarily have done so unless he thought he was plainly wrong, and he didn't. In our submission, Mr. Justice Butcher's analysis is persuasive and correct, and it would be helpful if this court comes to that same conclusion. It would be helpful for the court to deal with the point in its judgment, although I accept that in terms of the overall outcome of the appeal, it's of rather second-order importance. And the reasons which my learned friend gives for seeking to distinguish Aubrey are unpersuasive. the two critical points that Mr. Justice Butcher made was that, well, first of all, that the really critical point was that the disclosure, if it's going to be in public, Section 12 would apply. And in Mr. Justice Henry Carr's case, there was disclosure to a court which was in public. Now, in this case, as I'll give you the reference without talking it up, we made this point in our skeleton. Below, my learned friends went out of their way to explain that the disclosure they wanted to make to the ITC had a quality of confidence. It was all within the rubric of confidence. And your Lordship will find that, my Lordship will find that in the claimant skeleton argument below, at tab 48 of the supplementary bundle, at pages sub 311 and sub 312.
Is this what is known as the protective?
Yes, that's right. That's right. And that's why Mr. Justice Butcher's analysis, if it's correct, which our submission it is, it means that we are not in Section 12 territory here, and the learned judge below was right so to find. I've got to deal very briefly with the questions of delay and full and frank disclosure, because some unfortunate suggestions have been made by my friend about misleading the court on the part of Mr. Ayrton in his evidence. That is emphatically not what happened. Mr. Ayrton's evidence explains what happened. He explains that there was an inadvertent disclosure of the document within 193,000 other documents. He explains that the material which came from the other side in March was never made available to Ocado's in-house legal team or its UK legal team at all. And he explains, and so does Mr. Beanie at tab 45 of the supplementary bundle, what happened in the deposition of Mr. Limbo. But my learned friend gave an incomplete analysis of what happened there. It is true that the point was dealt with on a point of attorney-client privilege, because that arose as well as a matter of US attorney-client privilege. But the question of the WP privilege was discussed and was dealt with. Mr. Beanie and Mr. Ayrton explained this in their evidence. And the point is, in terms of delay, the point is that there was no reason for Mr. Ayrton or anyone else on our side, but the day when they walked out the door after that deposition, to think that there was any problem, if there was any need to come to court. It was only when, on the 20th of May, Ocado's in-house legal team and UK legal team saw the ITC filing from our then friend's client, which contained references to the without prejudice material, that they realised that steps were going to have to be taken, and steps were then taken and were taken speedily. Ending up in front of the judge, not before attempts had been made, this takes me to full and frank disclosure, not before several letters had been written to the other side, asking them to give undertakings so that the matter could be dealt with without having to run off to court. You will have seen from the chronology and from the judgment that at 13:41, 19 minutes before the hearing started, the original ex parte hearing, an indication was given that they had no intention of, as it were, doing anything with the material pro tem, but they had spent the week refusing to instruct Kirtland and Ellis to accept service of the application. And the primary reason why we had to go before the learned judge originally was to get an order for service out of the injunction application itself. And the whole purpose of that application was to get the application for an injunction, which we always accepted was going to be on notice, organised in a proper way so that it was service had been effected and so that the inter partes injunction hearing could take place. And that's why I spent quite a lot of time before the judge at the ex parte hearing dealing with service point. It was then necessary to obtain very short interim injunctive relief pending that hearing taking place. And although there are all sorts of allegations of failing to comply with the full and frank disclosure obligation, we don't accept any of them. And in particular, there had been correspondence, and there was a substantive letter of the 26th of May, it's in the bundle, it's in the references in the skeleton argument, where they did set out their position over 3 pages and did explain that they were relying on Rule 408. And the very first thing I did at the ex parte application, you can see from the transcript, was to say to the judge, there are 3 important communications I've got to show you. The 2 that have come in from the other side that day. But before I got anywhere, before I go any further, would you please read and digest, and really read and really digest all of that letter, because that was the letter which set out their substantive position. And the learned judge did so. And so the accusations that are now made in the skeleton argument proceed as if that hadn't happened. It did happen, and the judge understood what the other side's case was. And we did make sure that the learned judge had all the relevant facts before him. And moreover, we were only there to make sure that our principal application, which we always accepted was to be an inter partes application for injunction, could be got on as speedily as possible because of the looming deadline before the ITC. And that's what we did. So while we don't accept any of the suggestions that there was a failure to comply with the duty to the court, and you'll have seen from our skeleton argument that in any event the point doesn't go anywhere. The delay point doesn't go anywhere. And nor does the full and frank disclosure obligation point go anywhere, because even if there were anything in any of those points, which there emphatically isn't, we're simply not in the territory of it making a whit of a difference in terms of the substance, as my Lord the Master of the Rules pointed out a little earlier. And so far as the service of the order is concerned, well, we dealt with that in writing. It would have been much easier if service of the order could have been effected on the people on whom it was properly served at their place of work, which is what we attempted to achieve. We weren't given any cooperation in that. No doubt that there's a reason for that, but we weren't given any cooperation, and so other steps had to be taken. And that's sometimes what has to happen in litigation.
Unlikely to decide this case, I think, Mr.
I
McLean.
shouldn't think that's the point that your lordships will be concentrating on, Milady, in the judgment.
Just as a matter of interest, Mr. McLean, why do you need to serve the CEO at all?
Well, he's not served. Well, he served so that he is, as we understand it, the person who is directing the litigation. And as your lordship will know, when one obtains an injunction, one contemplates, obviously, what happens. How do we enforce this injunction? How do we make sure this injunction, as it were, sticks? And with a corporate entity, it might become important to show that personal service has been effected on the person who, as it were, calls the shots.
Yep. Thank you.
That's why. Unless I can assist, your lordship or Milady any further. That's all.
Now, Mr. Purvis, thank you very much, Mr. McLean. Mr. Purvis and Mr. Flynn, how important is it for you to get a decision out of us quickly?
It is important, my lord, because of the deadline. I think the deadline, the absolute deadline is the 7th of July.
7th of July is not very long away.
No.
What do you say, Mr. Purvis? You agree?
Yes, both
Right.
parties.
Well, in which case we'll retire for a moment and see what we can do.
Should I share your competence? Yeah. Well,
People, lawyers, decided on common language.
yeah.
You didn't know the way. You get your belt and braces on the trousers swap back. That's where you end up.
Well, I agree. But, I don't know. They seem to be. Yeah. It's a strange one. The thing is, you know what to say. So if I put the email to it, it goes, oh well, that's then not accepted. But you all still download.
One thing which it doesn't. Coming back. Logistics. One thing.
So if they can't agree amongst themselves.
Yeah. Well. That's good.
Change your mind.
They've gone.
Price?
Well, in the light of the fact that you need a decision, and there's some hesitation because this is a difficult case raising important issues, we have decided to dismiss the appeal, and we will provide our judgments in writing in due course, but we thought it appropriate that the parties knew that the appeal would be dismissed so that they can deal with the consequences thereof in the United States. And we are very grateful, we should say, to all counsel and solicitors for the illuminating arguments, both written and oral, which have raised what undoubtedly are interesting and difficult questions. Thank you very much. Oh, I should just say, we'll sit down just for a second. When you get the judgments, can you deal with them in the usual way, agree consequentials? If you can't agree them, we'll deal with those in writing.
Before you raise just one issue, that there is an issue of cost. Obviously, I don't expect your lordship to do anything about that now, other than may we have permission to make submissions in writing and give you the schedules.
On costs?
Yes. For the,
Yes, of course, but that'll be done after you've seen the judgments, I think. Yes. I mean, I can't guarantee, I'm afraid. The term is very busy, and we're all particularly busy, so I can't guarantee you'll get this before the vacation.
Can I also add one thing, is that when you receive the draft judgments, if there are any matters which you think should not be in the public domain, because the judgments will be open judgments, that you draw that to our attention.
Yes. Thank you.